So a theft case in Texas, if it's between $100 and $750, is a Class B misdemeanor. That means that the maximum punishment you can get is 180 days in jail and up to a $2,000 fine. The worst part, though, about having a conviction for theft would be just the fact that you have that conviction on your record. There's apartment complexes that people will apply to that will refuse you, as a guest or a tenant if you have a prior theft conviction. And a lot of times when we have a case like this, and it's that lower value, this is normally a shoplifting thing. Maybe it's from Walmart, maybe it's from, Dillard's or somewhere like that. We can often get our clients into some kind of a program that keeps them from getting a conviction like that. But that range of punishment ultimately is up to 180 days in jail. And we certainly don't want to have something like that for our clients. A criminal history report will include a theft conviction if it's a Class B or higher, sometimes even a Class C. So if it's less than $100, you could still have a conviction for that on your record, and that's no good. Every Texas district attorney's office has the ability to offer something called a pretrial diversion. And in theft cases, lower level theft cases like this, oftentimes when we have a client that doesn't have any criminal history, what we will do is get them to provide letters of recommendation from people that know them, that can say, that they're a good person. This is sort of a culmination of either some stress going on, financial or otherwise, and that they deserve a second chance. And so what happens in a pretrial diversion is it's kind of like a probation where you'll do community service, you'll do maybe a class online or in person related to theft, and then you'll be supervised for a period of time and drug tested. And at the end of that period of time, if you've done everything correctly, then they can dismiss the case. And what separates a pretrial diversion from a maybe a deferred probation, a regular deferred probation, is both of them end with a dismissal, but only a pretrial diversion can eventually be expunged off your record. And an expunction is the really important part because that's what prevents other people from seeing it. Even the prosecutor or the government that granted the pretrial diversion later on, if they were to run your history, they wouldn't see it either. Under certain circumstances, the prosecutor can offer you jail. Now, hypothetically, theoretically, every person who's arrested for theft at the Class B level has the ability to be sentenced between 0 and 180 days in jail. But if you don't have any criminal history, that's really unlikely. We've never had a client in that situation get sentenced to jail. If you have prior convictions for theft, really those are going to get bumped up. If you have 2 prior convictions for theft, it'll become a felony no matter what the value was. So you could steal a candy bar, and if you had 2 prior thefts, it's going to be a state jail felony. So people who end up with an offer from the state of jail time on a misdemeanor case have some aggravating circumstance. Maybe there was use of force when the item was being stolen, and it could be filed as a robbery, but they went ahead and filed it as a misdemeanor. Or maybe we've reduced the felony conviction down from a robbery to a theft, and part of that agreement was some kind of jail time. But it is pretty rare for somebody with no history to get jail time on a case like this. So the only way to remove something from your permanent record is an expunction. And even the term permanent record isn't a great term because there's no one record out there. The district clerk's office and the county clerk's office of every jurisdiction will maintain criminal records. The FBI has a database. The police officers have offense reports that they save. Same thing with the district attorney's office. When they request all that information from the various authorities, they will store that at their office. So in an expunction proceeding, it's a separate civil process that we do when we've gotten a case dismissed for someone, and it's only available if the case is dismissed. But what happens is we subpoena and we serve notice to all those agencies so that they're part of that civil hearing, and then a judge will say basically, look, the case was dismissed. A waiting period is either passed or the DA's office waived the waiting period. And then those agencies are given an expunction order commanding them to delete all record of the case, including the national databases. We always think that somebody who's charged with a crime deserves legal counsel. If you can afford your own attorney, then that's important because really the only decision you get to make in a criminal case that's 100% up to you is who do you have in your corner, who's representing you. And so there's so many pitfalls from the difference between a deferred probation and a pretrial diversion. One can be expunged, the other can't. And having somebody who knows all these things and can look at the facts of your case and give you the best chance to be successful is really important. We have clients who have had kids with them while they're doing the self-checkout, and they skip a few things, grocery items or hair products, didn't realize it, and walk out of the store and they get charged with that. If it's over $100 in value, all of a sudden you're looking at a Class B, and you really didn't mean to do it at all. And that's exactly the type of client that we handle and help every day. Yeah, so in Texas, a retail owner has the authority under what's called the shopkeeper's privilege to detain somebody for a brief period of time to assess whether or not they have committed theft. Now, technically, this is a civil right that the store owner has, but they can hold you there and call police, wait for a police officer to arrive. They can search through your items, and it's all deemed to be a legal search if they believe they have probable cause. And so most retailers don't do this unless they have observed something through their loss prevention team that says, okay, we think this person has concealed an item either in a bag or clothing, or we think this person has failed to scan these items and pay for them on the way out. Maybe they're in the bottom of the tub or something like that, and they scan the tub. That's pretty common. And so that shopkeeper's privilege allows them to detain you and search you before the police get there, and then report what they've found to the police. In Texas, a robbery is any theft that in the course of the commission of the theft or the immediate flight therefrom, bodily injury is either produced or threatened. So if somebody feels pain when you jerk your arm away from them as you're trying to get away from the loss prevention personnel, that could be considered a robbery, even if you didn't say, typically in law school, they say a robbery is your money or your life, and they threaten you with a knife, right? That's, in Texas, we call that an aggravated robbery. But you could have a simple theft from Walmart of, something that's a candy bar from Walmart, and the loss prevention person tries to stop you. You push them off of you. If that person falls and gets a bruise or something like that, that's bodily injury in the course of committing a theft or leaving from a theft. And that could be a robbery. So the penalty difference is extreme. So that little bit of a push could change a Class B misdemeanor with a maximum jail time of 180 days and likely no jail time at all to a robbery where the minimum punishment is 2 years in prison up to 20 years in prison. Thanks for watching the video today. As always, these are for educational purposes only. If you have a real legal issue, you need help, give us a call. If we're in the Galveston area or anywhere near Houston, we service that area, and we can talk with you, give you a full consultation, then get you the right advice. Thank you.